Kumekucha Kagombe, aka alias GG Kagombe.
Me, Miss Raila. We're here with my colleagues. Yeah, I'm going to introduce them, and then one of us is going to address the court. First Bishop and Evelyn Onura. And all of us are here.
Anybody for the accused?
Yes, my lord, good afternoon.
Good afternoon.
For the defense, we are 6 in number. My name is Brian Raila. I have Mr. Kahindi, Mr. Wahome Tuku,
Present.
Mr. Yuguna,
Present.
Mr.
Mr. Wahome?
Yes, President.
The other name is?
Tuku.
Mr. Kiyangi,
President.
and Mr. Were.
President.
And my lord, I will have the privilege of leading the defense team.
Yes.
This is our first appearance. We have found the information, however, the accused person has not been escorted for mental assessment. The reason being that the accused person was arrested on Friday. And our prayer is that the court issues an order for the accused person to be escorted for mental assessment before we come to the so our prayer that this person was married at Mutahi police station, and from where he was escorted for mental assessment at Kiambu level 5 hospital.
Have no objection to our client being processed for mental assessment. We will be, however, pleading this court. If you allow us to facilitate that process, we can escort him as counsel, together with the investigating officer on a day that should be appointed by the court, while he is out of remand. Your Honor, sorry, my lord, prior to our client being presented before this court, we had successfully obtained a pre-charge anticipated bond granted to him by your assistant, the Honorable Lady Justice Dora Dipoli at Kiambu High Court. My lord, it is on belief to plead with you, my lord, that since our client has only been formally charged, the anticipatory bond subsists until such a time that he will be asked to take leave. Our client is a member of the National Assembly, representing the people of Katundu South constituency. And to be fair, that is not a flight risk. You can't run away from this mandate, serving the people of Katundu South. He appreciates and is ready to abide by any conditions the court may give. He is ready to comply, he has already complied with placing officers. He will be before this court, my lord, as and when he is required to do so. Your Lordship, we expected the royal police for the state to lay a basis even why our client was to be held all the way before this court when, as per the particulars of the offense was committed somewhere in Thika. Therefore, our conclusion that, my lord, the state will not be acting in utmost good faith. On the very least, it defeats the objects of Article 48. It makes litigation extremely expensive without a basis being laid for. It's even a mockery. The judiciary is opening up courts all over. And we're not doubting, my lord, that we have got unlimited original jurisdiction over the matter, but I think it would be fair for the president to have indicated as to why you get to come for this way. You are in Kiambulo court, and you are told that you have to come. So my lord, that would be fair, and this my colleagues are very good to add, but we plead with you, my lord, that you consider extending those terms that are given by the Honorable Justice Dora Yukun until the time that please happen. Just to add that, my lord, as has been admitted by my colleague, our client has been custody from Friday, even against the express orders of the Honorable Justice to court, which we serve. It's a received court. He's arrested blatantly against those orders, and they had all that time even do a mental assessment of him. The doctors, rather hospitals work over the weekend. So that will be done so that you are here to commence the trial process rather than waiting until they ask for more time.
The file information, some record. And if you look at that anticipatory bail, there was no condition attached to it. What is there is that he should respond to summons by the police. And that anticipatory bail was given because he was apprehensive of arrest. And since he it was given ex parte and a date was given for inter-party hearing, there's nothing that stops the state from charging when investigations are complete. Therefore, my lordship, this person cannot be released to be escorted from his home to be taken for mental assessment. I think that application can be made at bail application stage. And with regards to the state not laying foundation as to why they are charging him here, this matter is being investigated by the DCI headquarters, which has the jurisdiction to charge anywhere in the country. Upon having reasons, yes, at Kiambu, yes. They have the jurisdiction to charge anywhere in the country. And they don't just charge in any jurisdiction without a reason. I would not care to go into the details of the case, how it happened, but there has a reason why the case was removed from the jurisdiction of Kiambu. Where I had as in charge to be filed before this court. And we mentioned to one of the council, and they did not have a problem with that. If they could have raised a problem, I would have started by laying that basis. Yeah. That is all from us.
Yeah, still reading my order. Yes, what did you understand?
Sorry, Mama?
I've already started writing my order.
Yes, that's one point. My lord, it's not correct when the state tells you that this person has been charged. Even on the extreme, if you read straight the imagination of the court, charging means reading out a plea. That has not been done. That's why we are pleading the court. But the orders that were given by the Honorable Justice of the court considers extending it until that time when he's charged. When he's charged, then of course we down can be forced.
Counsel, it is common ground that before murder plea is taken, one has to undergo mental assessment, which in this instance has not been done. I do therefore order that the accused person is taken to Kiambu Level 5 Hospital on Wednesday, 5th of June, to have the assessment done. The second issue is whether or not he should be released on the anticipatory bond terms issued in Kiambu HRCC miscellaneous application number 80424. This was opposed by the State Council on the basis that the information had been filed and that anticipatory bail was no longer applicable. On this score, I do agree with the State Council that anticipatory bail granted would only apply before formal charges are filed. Once the formal charges were filed, the same anticipatory bail has been overtaken by them, and the accused person is allowed to apply for new bail bond terms once formally charged before this court. Finally, on the issue of the court handling in this matter, it is not in dispute that the High Court has jurisdiction over the country, but at this point the court will not make a definite determination on the matter. The accused counsel is at liberty to file a formal application for the court's determination as to whether this case will be heard here or not. We take plea on Friday. Friday is 7th. Seven. So plea will be taken on 7th of June at 10 a.m. Accused person to be managed at Mutembei police station until then.
Not
They must apply.